What is Kamala doing hiring a convicted criminal onto her campaign? Doesn't that shatter that stupid talking point on the right? How do you want to plead to that charge then of reckless driving? I plead guilty. So the court says, all right, well, the court finds then the factual basis by the county attorney is sufficient. You guys have settled this. The court accepts the plea of guilty and finds the defendant, Tim Walz, guilty of reckless driving. Tim Walz's DUI records now are public. We're going to go through them in detail today, including the transcript from when he entered his change of plea. We've got a police report, very limited. It's an old 1995 case, but it's coming back to bite him. And this has come forward from Alpha News. What is Kamala doing hiring a convicted criminal onto her campaign? Doesn't that shatter that stupid talking point on the right? So every time they say Trump's a convicted felon, Trump's a convicted felon, say you guys a convicted reckless DUIer, convicted reckless driver, got a misdemeanor for driving well over the legal limit at 0.128. Now, if you look around, most states are 0.08. In Arizona, the extreme DUI is 0.15. So he's under the extreme level, but he's still well over the legal limit, like not even close. Like you're not beating that DUI on a margin of error. It's not a 0.082 or something like that, okay, which is right on that margin. It's much higher. So we had a blood alcohol concentration of 0.128 at the time of the incident, long time ago, don't get me wrong. And it's something that he got a good plea deal on, but it's still a conviction. So this came over from Alpha News. This is the mugshot, came over from Kyle Becker. Clip this one for us. This is the mugshot of Tim Walz after he got his DUI. And this is what the police report looks like. Tim Walz in the county court of Dawes County, Nebraska. CR 95-512 in the matter of Timothy J. Walz. This is an affidavit of reasonable or probable cause for an arrest without a warrant. It's a misdemeanor. Long time ago, 1995 case, as you can see from the CR 1995. It says the undersigned, a law enforcement officer, being duly sworn upon, here does say the following. Pursuant to state law, I have information and determined detailed without a warrant that the above named person on September 23rd, 1995 at 21:30 p.m. DWI under Nebraska code. Now here's what this officer says upon pulling over Tim. He says, all right, at approximately 21:30 on 9/23/95, the officer writes, Trooper Razgorshek, number 222, observed a silver 93 Mazda Northeastern on the 65 B176, probably the mile marker, traveling at a high rate of speed. The vehicle was tracked on radar, fast speed, 96 in a 55 mile per hour zone. Now in Arizona, that's also criminal speeding. If you go too fast, that's criminal speeding. Contact was made with the driver, who was identified as Timothy Walz, date of birth 4/6/64. A strong odor of alcoholic beverage was detected emitting from Mr. Walz's breath and person. Mr. Walz was given a field sobriety test, which he failed, and we know what those tests are. Mr. Walz then submitted to a preliminary breath test, a PBT. That's something else that you can reject in many states, not all states. In Arizona, you can, which he failed. And then he was transported to the hospital where a blood test was taken. Okay, now that's the one that actually matters. These PBTs, these are handheld tests. They're just giving them an estimate. It's not even scientific. That PBT test number doesn't even come in as evidence. All it does is give them probable cause, as does the field sobriety tests. That's all they're for. So, okay, he comes in, he says, yep, failed the PBT, boom, blood comes back. He was then transported to the county jail, booked in at approximately, looks like 22:45. It's about an hour, 15 minutes on 9/23/1995. Now, the offense committed was in my presence, so he's sitting on the side of the road at Northeast 65 B176, doing speed patrol, sees a 96 and a 55, pulls the guy over, he's lit, does some roadside agility maneuvers, field sobriety test, does a PBT, gets arrested, and he's booked. All right, happens, very common. I've worked on, I don't know, maybe 1,000 of these cases. So let's see what else happened. Then we go to court back in 1995. So that is the traffic stop. He gets pulled over. He gets a lawyer, it looks like, for the case is a transcript, looks like a change of plea proceedings. State of Nebraska versus Timothy Walz. This is the arraignment, plea, and sentencing. Okay, so this is everything that happens all in one. So here's how it works. The judge comes out. He says, all right, Nebraska. Says, at this time, we'll take up the case, State of Nebraska versus Timothy Walz. Says, Mr. Walz is present in the courtroom. room. His lawyer is here. Mr. Nolan is here, the Dawes County attorney, small court. Is there going to be an amendment to the complaint, then by plea agreement? He says, to the complaint, then by plea agreement. Is there going to be an amendment by a plea agreement? He says, yes, Your Honor. Pursuant to a plea agreement, the state would reduce the charge to reckless driving. And this is another common thing that a lot of DUIs try to get pled to, but a lot of government offices won't reduce them to reckless drivings because of the grants, because of the money. They have to get a certain number of DUI convictions, so they don't give you a benefit. So you just get stuck with reckless driving, even if you're at like at a .086 or whatever. They just don't care, at least in Arizona. Now, from a DUI. Now, the court and Mr. Hartford, there will be a plea then to the indiscernible. Judge, that's correct. I think that the complaint may reflect that. It may not. I'm not sure if there was a speeding count. So normally when you get a criminal ticket, you probably had them like, you know, your name's up here, date of birth, all your identifying information. Then you have the charges down here. And so here he probably had DUI. Then he probably had like a speeding charge, right? He had two of them, like 1 and 2 is what they're talking about. Government says, it's my understanding that the speeding and the DUI would be amended. So they're just going to take these two. They're going to amend those to reckless driving. Okay, so practically the way this is going to work, this is a nice deal from him, is the prosecutor is going to basically, maybe even on the same form, scratch this out. Okay, we're just going to delete those. We're going to turn those into a reckless driving. And that's going to be the new charge. And if you do that, then we'll plead guilty to that. Okay, then we'll just plead guilty to the charge. You just amended it. You changed it to something different. Then there will be a plea to that, judge. Okay, he says, okay. So will there be an amended complaint? Will you just scribble that out like I just did? Will you file that? He says, yes, Your Honor, we will. Okay then, Mr. Walz. This is Governor Walz now. We will proceed on today then. You'll not have a written copy of this complaint because we're scribbling it all together right now. Like they did everything in one setting. This is how it works in some small towns. Some small courts, in fact, I've been to several of them where you could get amazing things done because it's just like, let's get this done with. But it will charge you. So like, you're not going to see this, but we're writing it now. We're going to call this reckless driving. Now, reckless driving carries a maximum of 3 months in jail, $500 fine. This is the maximum possible penalty. There is no minimum penalty required by law. A lot of other states have mandatory minimums, like at least a day of jail or something. There are no court order suspensions on reckless drivings either, but there could be a loss of a license if you have a points problem. Do you understand that? Walz says, yes, Your Honor. Now, Mr. Walz, also, it's true that on reckless driving, somewhat similar to a DUI second offense, DWI, then at the later time, it would be a more serious than a first. Okay, if you get a second reckless driving, it's worse than the first, just like a second DUI is worse than the first. There's an enhancement. Do you understand that? Yes, Your Honor. And finally, Mr. Walz, the complaint would allege that you drove a vehicle in a manner as to indicate an indifferent or wanton disregard for the safety of persons or property. Do you understand that? This is what the law says about reckless driving. If you're going to plead guilty to this, you have to agree that you did the thing that you're pleading guilty to. Like, we can't change this into shoplifting, right? Because it's like not even close. Reckless driving, it's like, okay, if you're under the influence of alcohol, yeah. Are you indifferent to the safety of others? Yeah, kind of. Is it a wanton disregard for the safety of others? Yeah, kind of. So it applies. Do you understand that? Yes. Now, Mr. Walz, how do you want to plead to that charge then of reckless driving? I plead guilty. And again, do you understand what this charge is now and what the penalties could be? So they just changed it. Okay, they walked in, they just changed it right there at the arraignment, the plea, and the sentencing. Yes, Your Honor. Have you received any promises or threats or pressure to get you to plead guilty? No, Your Honor. And this is wild, right? For anybody who's had a DUI or ever known anybody who's gotten a DUI, how amazing this is. Okay, people have hired me and my law firm when I was at the R&R Law Group building our team there, you know, thousands and thousands of dollars to represent them on stuff like this because it doesn't work like this anymore. This is a totally different time. The county attorney has agreed to dismiss these other two charges and only charge you with reckless driving. Has anything else been agreed to by the county attorney that you know of? Are you doing anything else? No, Your Honor, not that I know of, says Walz. Do you understand that by pleading guilty now you give up your right to a jury trial? Walz says, yes, Your Honor. And then your right to see, hear, and have a lawyer question the witnesses against you. You give that up too? Yes, Your Honor. Also, you give up your right to testify and to present a defense, right? Yes, Your Honor. And finally, you give up the right to remain silent. Yes, Your Honor. And so the court finds then the plea of guilty is knowingly, voluntarily, and intelligently made. Mr. Nolan, the defense attorney, can you please provide a factual basis then? And so he's going to describe the actual crime. He says, I don't remember the exact date. This is kind of amateur hour right here. You never have to remember the exact date, all right? You just say, of course, Your Honor, happy to provide a factual basis at the time, date, and location listed in the complaint. That's all you say every time. Then you go on. It's just, you know, it's okay. It's 1995. They probably didn't know any better. And Your Honor, and I don't have that file. He's like, I don't even have the file. I don't even know what I'm looking at. He says, okay. So you'd say at the time, date, and location location listed in the complaint, just to, little tip there. I don't know if Mr. Nolan's around anymore, but, little tip. Says Mr. Walz was driving south of town on the 385 in Dawes County at a high rate of speed. Actually, he was driving away from the police officer. I think that eventually he hit a speed of over 80, as I recall. When he was stopped, he was given a blood test, which he did show a 0.128 blood alcohol. Thus, that would be the basis for the reckless driving, Your Honor. I'm sorry, the exact date I don't have. It appears on the complaint. There you go. Finally got it in there at the end. Okay, so that's September 23rd, 1995. He says, yes, September 23rd, 1995. So the prosecutor comes back in. He's like, all right, look, I got to add some stuff to that because that was like pretty basic. So let me add some stuff. Prosecutor says, Your Honor, I think I can probably just add a little bit to that. Says, I apologize both to the court and to Mr. Nolan, for I thought that this was scheduled for a pre-trial conference today, so I had Mr. Walz come today. So I was going to talk to him about a plea deal, probably. It doesn't make sense, like you're taking a plea deal. Okay, I appreciate the court allowing us to do this today. This is the government prosecutor. Says, it was in fact the date that was alleged in the complaint. You guys got it right. He initially, I think, was clocked by one of the state patrol officers going at about 70. Now, this is weird. The state patrol officer turned around, and then this is a little bit bizarre, but also Mr. Walz thought that somebody was chasing him. The officer didn't turn on his red lights, and somebody came up real fast behind him, and he didn't know what they were doing, and so he sped up to try to get away, fearing that somebody was after him. And by the way, this happens all the time with cops today. All the time. All the time. Cops race up on somebody, they freak out, and they say, oh, you were weaving in the lane. Oh, you deviated from the lines. Oh, they drive like lunatics. I've seen it in body cams. Now, lo and behold, it was a state patrolman that was behind him. So the faster he went, the faster the state patrol officer went. Finally, he did turn on his red lights. The speed was fairly excessive, Judge, a lot over the speed limit, says the prosecutor. I don't even know what was alleged in the complaint, but it may have been 90 something. Wild that a prosecutor's like, I don't know. Mr. Walz had been drinking, so I think there is a sufficient factual basis, Judge, to support the plea. Government's all in. So the court says, all right, well, the court finds then the factual basis by the county attorney is sufficient. You guys have settled this. The court accepts the plea of guilty and finds the defendant, Tim Walz, guilty of reckless driving. Any comments from the state on sentencing? Defense attorney says, well, Your Honor, I think given the circumstances, Your Honor, that the fine that the court has been imposing on a reduction from a DUI to a reckless would be appropriate. Prosecutor, any comments? Well, Judge, I do have a few comments, says the government. Mr. Walz is asking the court to impose a fine. This is the defense now. Says, I think that this is the kind of case that a fine would not show any disrespect for the law. He did have a relatively low test of a 0.128, not by today's standards. A 0.128 is not good. You're not getting reckless driving on that at a Phoenix Municipal Court. No way. Phoenix Municipal would not give you that at all. In addition, I believe, like ever, they would never give you a reckless driving for this. Never. In addition, I believe this court has suspended the test result as a result of the Smith case, and the Maggart phonetic case adds some of those cases. More importantly, I think the court should know that Mr. Walz is a teacher at Alliance High School. Been quite a few years. He felt terrible about this, was real disappointed, I guess, in himself. He went through and immediately reported this incident to his principal. He resigned all of his extracurricular duties at the high school. So this is the defense attorney, laying it on pretty thick, which included some coaching responsibilities. He also offered to resign his teaching position because he felt so bad. I think takes the position that he's a role model for students. He let them down. He let himself down. Because of that, he was ready to resign. Fortunately, the principal talked him out of it. He did, in fact, though, resign from his extracurricular stuff. Now I think he's taken an opportunity to turn this into a positive for him. Now I guess he's ministering, so to speak, to the students about all the bad things that can happen if you get a DUI. And so I wanted the court to know that he did lose his license for 90 days administratively with the DMV. He's done that suspension. He's jumped through all the hoops. He's got his license reinstated. I think because of these things, Judge, and because I think that there's a good to come from this, in fact, that he now hopefully can reach younger people, we think a fine would be appropriate. Mr. Walz, anything that you want to say here before the court imposes a sentence then? No, Your Honor. Mr. Walz, on this case, there will be a fine of $200 plus court costs, which will include a test fee. Mr. Walz, I guess it may, I don't know if it may or may not surprise you, but we do have school teachers come in on this offense, and I always have the same concern that your attorney has expressed. This is a real problem for me to see a teacher get picked up for this offense because you do have a role model. That's why you're a teacher. If you didn't think you could affect children's lives, why would you be a teacher? I want to share a couple things I tell people on a DWI offense. The first thing I ask them is, why is it against the law to drive with a 0.18 alcohol content? Why is that against the law? And Walz says, well, it's not just statutory. It's a dangerous situation, Your Honor, not just to myself, but to others who aren't even involved with it. So he's kind of like, poking at him. Absolutely. You're an impaired driver at that situation, and you run the risk of killing yourself and killing against somebody else. What is the first effect that alcohol has on you when you drink alcohol? Walz says, I think it impairs your ability to make sound decisions, correct decisions. Right. The first effect is that it affects your judgment. You'll see people doing dumb things, stupid things, says the judge, long before they have trouble talking, walking around, and vision problems, etc. Most people then get picked up for DWI or in the same situation that you were in, when you think you've had a little bit to drink, but you think you can handle it. But the problem with that is that alcohol has affected your judgment, Tim. If you hadn't been drinking, you would have known that you probably shouldn't have been driving. So the rule is you don't drive a vehicle after you've had more than one beer. It's a good rule. Anytime you've had more than one beer, you don't drink or drive the vehicle, or more than one drink. In fact, in Arizona, the law is impaired to the slightest degree. If you feel it at all, that's illegal. Or more than one drink, and you'll never be back in court again. Just follow that simple rule. Mr. Walz, I sincerely hope that it's true that you've turned this. There's an old saying, every adversity has a seed of a greater benefit. Finally got it out. Must be an old judge. If you can take this into a better thing for you, then it's great. I would certainly suggest that you, in your position, that you educate yourself on the use of alcohol, because it's a terrible problem among teenagers. It's a terrible problem among college students. Unless we get support from the people that have an effect on children's lives, a lot of children grow up and have terrible lives because of the use of alcohol and their abuse of alcohol and high risk use of alcohol. So I certainly hope, Tim, you've learned from this, and I hope you can share that with your students. Mr. Walz, if you take this out to the clerk and settle up with the clerk, then Walz says, thank you, Your Honor. And he says, that's the end of the proceeding. So that's Tim Walz's DUI, now unsealed and available for all to read. The campaign manager of Tim responded to this in 2006. He was running and said that this was a result, the arrest by a state trooper. The campaign before lied about this, said the arrest of a state trooper was the result of a misunderstanding caused by Walz's deafness. His hearing has since been surgically corrected. The incident was reported by a blog. We know he got pulled over, 96 and a 55. An affidavit of probable cause we read through. He pleaded not guilty, and he sought to suppress the blood alcohol test in court. Wow. According to court papers. It's not what we saw. Looks like they had everything all done in one day. He paid a $200 fine. Walz's campaign manager, Carrie Greeley, didn't dispute that Walz was speeding, but Walz was not drunk. She said he was not drunk. Campaign manager Carrie Greeley didn't dispute that Walz was speeding, but he was not drunk. That's not what the blood results said. She attributed the misunderstanding to Walz's deafness, a condition resulting from his years of serving as an artillerist in the Army National Guard. He's deaf from serving in the Army National Guard? Was he launching artillery? And by the way, 0.08 is the presumption of intoxication. Okay, if you're at 0.08, the law just says we can just presume you're drunk. There's enough evidence there. They do testing. They actually get people drunk. They measure their BAC and they see what they can do. And so they say at 0.08, you're drunk. So if you're at a 0.128, probably drunk. They said he couldn't understand what the officer was saying to him because he had his ears blown out in the Army National Guard. That is the DUI saga of Tim Walz. He had one. It's quite old. I'm not too worried about it or concerned about it because it's an old DUI. But they're the ones who drew out this very important credential about not having any convicted criminals on a campaign because it's too dangerous for American democracy. They kept telling us Trump's been convicted of crimes, even though he really hasn't. You could make the argument that he was convicted by a jury, but a conviction has not been entered into the record because he's not been sentenced yet. So check a background report, see if there's a conviction on there. There's not going to be. So Walz, though, definitely has one. Kamala just brought him onto the campaign. So only one campaign at this point has a bona fide candidate with a bona fide criminal conviction on their records, and that's Kamala's campaign.